on, strap yourselves in. Starting in colloquy with Ms. Hart.
Ready? And you are instructing him not to answer, I assume? That seems to be what your tactic is?
Yes, I am instructing him not to answer the question.
Ms. Hart, let's not lead him into any of this here. Don't prompt him.
I was just going by his pattern of this morning. I figure I am saving us a step in this part.
Fine. Between the time that you first filed an appearance in the Kerr litigation and the argument for the motion for a new trial, did you ever form an opinion that there was a conflict of interest between Mr. Mann and any other of the parties that you represented?
Once again, counsel, this calls for the work product. I just cannot possibly allow him to answer questions of this nature.
Did you attend the depositions of Mr. Michael Ross in the Kerr litigation?
I think that the record here speaks for itself. This is a matter of record, but I will allow him to answer the question.
Yes, I attended the depositions.
At the time that you had attended Mr. Ross's depositions, had you previously met with Mr. Mann?
I am not sure. I cannot remember when it was that I met with him or when the deposition was.
Okay. Silence. Okay, 11 to 12 doing the same thing. Regardless of which came first, after hearing what Mr. Ross had to say about the case and talking with Mr. Mann, is there anything that either of them said about the subject matter of the lawsuit that led you to believe that there was a conflict of interest between Mr. Mann and your other clients?
Calls for work product. Objection. I instruct him not to answer.
Did you attend a deposition of Walter Morris on or about December 29?
I don't know if the date is correct, but I attended a couple of his depositions at least.
After considering what Mr. Morris had to say, was there anything said about the subject matter of the litigation that led you to believe that there was a conflict of interest between Mr. Mann and other clients that you represented in this case?
Objection. The question calls for work product. Same instruction.
Did you have a written fee agreement with respect to your representation of the defendants in the Kerr versus Watts litigation?
The question is irrelevant. If you want to make a reference to the agreement, then I suggest that you...
Yes, let's have him refer to it.
Speedy, okay, from 12 to 13, picking up with Ms. Hart.
Ready? I believe that we all want to keep this proceeding today proper and correct.
Well, he has already made the reference, Ms. Hart. I do not see why we should take the time to have him go over it again.
Well, in any event, I am instructing him not to answer the question.
On what basis, counsel?
On the basis that the matter is irrelevant at this point. I don't see the relevancy.
Are you saying that you think a written fee agreement is irrelevant in this current litigation?
Yes, that is exactly what I am saying. Very well put, counsel. That is exactly what I am saying.
Are you following your attorney's advice and not answering the question as to the existence of a written fee arrangement?
Yes, I am following my attorney's advice.
Is there any written document which discusses your compensation for representing Mr. Mann in the Kerr litigation?
I don't know of one.
Let us go back to the meeting that you had with Mr. Mann shortly before the trial. As best you can recall, did Mr. Mann say when you told him that you felt he was not cooperative?
What do you want? Do you want something other than what I have already testified to, or in addition to what I have already told you?
Okay, we'll go from that point to minute 14. Here we go. In addition to what you have said.
I don't recall. I will have to have the reporter read back the testimony from my deposition.
No, I want something other than what you have already told me.
I don't recall what I told you this morning. It is on the record. Please have the reporter read it back to me so that I will know what I have said. I can't tell you anything new until I know what can be classified as being new and in addition to whatever it was.
Maybe you should repeat the question. I don't think he follows you.
Yes, I do. I am saying that I can't say anything unless I know what the old stuff is.
Well, I have not previously asked you what Mr. Mann said to you.
But I have told you some things as part of answers to other inquiries. I don't recall now exactly what I said an hour ago, and I don't want my responses to be incomplete.
Okay, we'll do one last minute at 200, so from 14 to 15.
Translation, I lied and I don't want to get caught.
Okay, here we go. Ready? Fine, Mr. Scott. What did Mr. Mann say to you in response to your statement when you told him that you felt he was not cooperating? I have not asked that question before, so it deserves an answer.
I was not saying you had asked it before. I said that in answering other questions, I have given you part of that information.
Well, without the testimony being read back, why don't you give me the most complete answer that you are capable of giving me?
He advised me that he didn't remember any facts from that period of time, other than what he testified to in his deposition, and the facts that were set forth in the deposition transcript from the Baltimore case, which I had with me at the time.
Let me clarify something. You said facts from that period of time. Is that in reference to the period of time during which events took place that actually gave rise to the Kerr litigation, or during the period of trial?
The period of time during which the events took place.
Was there anything further that he said?
He said he didn't want to discuss it.
Enough of that craziness, huh? Do more of 200? Well, I was gonna do a chunk at 175. Do we wanna do more minutes at 200?
Sure, that's
If
like,
no one minds,
that's fine with me.
Okay.
I'm down to
Let's keep
Yeah.
going.
push it a little more.
Do you wanna do a longer stretch at 200?
I
Or is
don't-
the 1 minute
Yeah,
I think the 1 minutes are
okay,
good.
We can do more too.
Because it's above your speed and I don't,
Yeah.
yeah, let's do one. Okay, let's do a couple more. Let's do from 15, I'm gonna ask that question on line 8.
Okay.
And- Yeah, we'll do 15 to 16. Yeah, page 12, line 8. And we'll hit the watch at 15. Okay, so it's Q by me.
Okay.
Q by Talk. Is that it then?
Well, I am trying to remember all that he said to me in response to that particular inquiry. He may or may not have advised me that he had worked with Mr. Kerr, or that he had worked with him at a different company here in town.
Would that have been all flights air freight? Would that be it?
I don't recall what he said. I don't remember his saying that. But in response to your question, he basically said that he didn't have any other information, and didn't remember anything, and couldn't or wouldn't be of help.
What was that? I'm not sure I understood you.
He couldn't or wouldn't help us. It is just that I am not sure of the language.
Which Mr. Kerr did he say he had worked with?
It seems to me that he said he worked with Danny Kerr, but that may not be it. I pointed out to Mr. Mann that I had heard from the start that he was going to testify for the plaintiffs. He didn't deny it.
Mr. Mann didn't?
No, he did not.
Did Mr. Linden notice the production of Mr. Mann as a witness pursuant to the code section which permits a party to call an opponent as an adverse witness?
I suspect that to be so.
Okay, let's go from 16 to 17, starting with an answer.
Ready? I suspect that to be so, but I am not certain.
Did Mr. Linden in fact call Mr. Mann to the stand?
At trial?
Yes.
Yes, he did.
Was the testimony at trial consistent with the testimony at the deposition?
That calls for his work product, and I instruct him not to answer. Counsel, the record speaks for themselves as to whether or not the testimony was consistent.
Prior to the commencement of the trial, did you ever attempt to negotiate a settlement on behalf of Mr. Mann?
Alone, on behalf of Mr. Mann by himself?
That is what I'm asking, yes.
No, not separate from the individual defendants.
Did you ever attempt to negotiate a settlement on his behalf along with a settlement for the other defendants?
We talked about it,
Who is we?
Lyndon and I.
When was that discussion?
I think we talked twice.
The first time? When was the first time?
I can't pin it down.
Do you recall talking with him regarding a settlement including Mr. Mann along with the other individual defendants?
No, not specifically.
Now then,
Let me finish my thought.
go ahead.
Mr. Lyndon did not seem interested in a partial resolution.